The Citizens United case, now before the Supreme Court, has the potential to radically reshape decades-long campaign finance rules. Bradley Smith, former chairman of the Federal Election Commission and founder of the Center for Competitive Politics, believes the First Amendment does, in fact, constrain attempts by the government to limit speech, even when that speech is paid for by a corporation. He spoke at the Cato Institute September 8, 2009. The full event is at cato.org.
Well, at oral argument, the Deputy Solicitor for the Deputy Solicitor General for the United States made the argument, and you really should look this argument up and read it. It's about 12 pages of the transcript at this point. He argued quite vigorously that, in fact, the federal government or state legislators had the power to ban books. They could ban books and movies. He said they could ban the internet. They could ban newsletters if any of these things were published by a corporation. And of course, most books are published by corporations. Now, this drew some rebukes afterwards from people who have generally been supportive of campaign finance regulation. They were kind of stunned. They said, what was he thinking? You know, why would he make these outrageous arguments? He didn't need to go that far. But Solicitor Stewart had not gone walkabout here. This was what the government briefed. This was exactly what was in their brief. And in fact, the reality is this is what has been in the government's briefs for over 20 years. And this is what Austin v. Michigan Chamber of Commerce says. That's the reality of the situation, that if a corporation pays for something political, the government can ban it. Now, within that context, the government has been willing to recognize certain exceptions. Stewart seemed to think that there was probably a constitutionally required exception for the media, and he suggested that maybe there were others. He did recognize that the Supreme Court in Wisconsin Right to Life v. Federal Election Commission had trimmed back somewhat the nature of ads that would qualify as political ads that could be regulated. But this has been the government's position. It can regulate books and movies if it chooses to do so, and can regulate, presumably, most any kind of speech paid for by a corporation. And Austin says it can do this because of the unique characteristics of a corporation. Now, as to the specific question asked then, by the way, you could almost hear an audible gasp in the room. Even longtime supporters of regulations such as Justice Souter seemed a little bit taken aback to have the government's position put forth so boldly and honestly. It's just usually not presented that honestly. People don't usually like to say, here's what we're about. We're trying to limit this speech. We're set for oral argument. Now, the question the court asks is it necessary to overrule McConnell v. Michigan or McConnell v. FEC or Austin v. Michigan Chamber of Commerce? And I think the general answer has actually been, even from those briefing as Amici on the side of Citizens United and Citizens United itself, well, it's not absolutely necessary, but you really need to do it. You ought to do it anyway. That is, it is almost certainly possible for the court, and the court may yet come up with a narrow basis for ruling in this case. I think it is very unlikely that they will argue, that they will uphold the government's position in its entirety that the government had the right to ban advertisements for Hillary the movie, to prohibit its distribution through video on demand, and so on. But the government could come up with a position something like, well, movies are covered by the press exemption of the statute. They're not, but sometimes they'll twist the language of a statute to say they are, just to avoid the constitutional question. They might try something else to say, well, this is different because listeners have to seek out the information, at least in terms of getting the movie. Although that strikes me as beginning to sound a lot like time, place, and manner restrictions, which the court has long recognized are not really applicable here, and I'm not sure is a distinction that would matter, but it's a plausible one. But in any case, doing so would leave the law really something of a shambles, and it would, I think, simply put off the day of reckoning. The fact is, the law is already convoluted, complex, and full of loopholes and exceptions precisely because the law regulates political speech, and when it gets too close to the core, even people who really kind of want to do that tend to pull back. And so as a brief that was signed by myself and 7 other former commissioners, including a couple who are here today, noted, it was drafted by the legendary Jim Bopp, who I see back here in the audience, noted already the law regulates over 70 different types of speakers, whether you're speaking as a corporation or a partnership or a party official or a candidate or a union and so on. It regulates over 30 different forms of speech with their own particular rules. I remember when McCain-Feingold was up for grabs, and in fact, in years later, a common cry of Senator McCain and others in that camp has been the same rules should apply to everyone. And I've always thought, where's that come from? I mean, we're not even close to having the same rules apply for everyone. There is no one set of rules for which just a few people are standing outside. There's a complex maze of rules. Again, as we pointed out in our brief for the former commissioners, it takes up over 200 pages of statutory language, well over 500 pages of regulations, over 1,700 pages of explanation and justification. You've got a couple thousand advisory opinions by the commission interpreting all this, and so on and so on. All a far cry from the eloquent language of the First Amendment, eloquent in its simplicity, Congress shall make no law, which, even if we don't take an absolutist position towards it, seems to be somewhat violated by this convoluted nature that our law has reached. So I think that it would have been very tough for the court to say, yeah, let's carve out some more exceptions. And I'm not sure how well those exceptions would hold up because of the changing nature of technology. For example, suppose the court says, well, okay, movies are going to be covered under the press exemption. Might be a narrow way the court can do it. Well, it doesn't take much to do movies anymore. I mean, people make some pretty good movies. You go to YouTube, you see some pretty good stuff there that folks can make, and you can distribute these things quite easily through video on demand, through internet distribution, and so on. Similarly, the internet itself blurs the line between the idea of a traditional press and everybody else. The fact that changes in the industry in the press, where companies like General Electric and Disney own television networks, you no longer have sort of the family-owned newspaper dynasty. Rather, you have corporations that have the right to speak because they own newspapers or television facilities, and corporations that don't have the right to speak because they don't own newspapers or television facilities. And you have individuals who can increasingly creep in on those roles. So I think that ultimately you can see in a whole variety of ways that it's getting very, very hard to make these long exceptions stand. And it was only because of these exceptions, it was only because there was an exception for the press, the institutional press, that somehow I think the law was able to stand. I think without that exception, nobody would have dreamed the law was constitutional at any point in time, right? But an exception for the press might have made some sense in the 1970s when we could kind of identify press. I'm not sure it was a good constitutional doctrine, but at least we knew who they were. Nowadays, that line is so blurred that I just don't think it's a workable type of exception in any case. So it's a difficult situation in which supporters of the law are placed. They've argued repeatedly that the law has been in effect for many years, but that's somewhat overstated because for many, many years, while the law prohibited corporate expenditures in races, it was either not enforced or it was very easily, to use the phrase these days, circumvented, because the Supreme Court itself recognized that you couldn't limit all this speech. They said unless it's got this express advocacy component, vote for, vote against, support, defeat, corporations can still largely fund it. They can fund these issue ads. And the court recognized that those issue ads were often as effective as any other ad. That's just the way it was to protect speech. So only with McCain-Feingold, well, not only, but increasingly, and with McCain-Feingold, the latest step, does it become more and more important for corporations to find another way to speak, because McCain-Feingold now begins to say, well, you can't even do issue ads if they're close to an election. In other words, as we keep closing off avenues of speech, we push further and further toward these extreme ends that are going to have to be dealt with at some point.
Bradley Smith is a former chairman of the Federal Election Commission and founder of the Center for Competitive Politics. You can watch or listen to the full event at cato.org.